Introduction to Mediation. Hi, we are the staff mediators for the 15th Judicial Circuit, and we're here to talk with you about being prepared for your mediation. None of this is legal advice. In this video, we will tell you a little about mediation. The goal of mediation is for the parties to reach their own agreements that help them resolve the things that bring them to court. It is a chance to think about things in a different or creative way and to try to find common ground with the other person. The alternative is to go to court where a judge or magistrate will make decisions for you and your family. The process is basically the same whether both parties appear in person or either or both appear by video or audio conferencing. Once you appear and listen to the mediator's introduction, you will make your own decisions in the mediation. The mediator will attempt to help with the decision-making process by summarizing some of the things you say, by offering alternatives or making suggestions and/or by asking questions about your decisions. The mediator cannot decide things for you. The mediator is neutral. Mediators do not take sides in a mediation. You may feel like the mediator is against you, but you can be assured that the mediator is neutral, and it is a normal part of the mediation process. With some exceptions, everything communicated in a mediation is confidential. That means that mediation communications cannot be repeated to anyone outside of the mediation. Mediation communications are not just what is spoken, but include documents, pictures, gestures, and almost anything else that goes on in the mediation. In addition, and with some exceptions, mediation communications are also privileged. That means that no one can share mediation communications with the judge without a clear agreement. In mediation, each party has the opportunity to meet with the mediator separately. It is an option and not a requirement. If you meet with the mediator separately, in what is called a caucus, you get extra confidentiality. The communications in a caucus cannot be shared with the other party without giving the mediator permission. If you reach an agreement in mediation, the mediator, or the lawyers, will prepare the agreement. That agreement may be printed for signature or sent for electronic signature. Most of the time, it is expected that the agreement will be signed at mediation or shortly after. Not every case reaches an agreement in mediation. That's okay. Sometimes mediation helps parties move in the same direction, and they settle later. Sometimes cases need a judge to make a decision. If you need more time to mediate, your case can be adjourned to another day. At the end of the mediation, the mediator will file a report with the outcome of the mediation only. The report will not include any information communicated in the mediation without clear agreement. Some other rules about your mediation. If you are on Zoom or the phone, you should be in a private place where no one can hear either side of the discussion. Wearing earbuds does not stop those around you from hearing what you say. You should not be in a moving vehicle. Alone in a parked vehicle is fine. You should not be in bed, running errands, getting coffee, or at the dentist. If you have to work, take a break and find a private place. During your Zoom mediation, you are expected to be respectful with proper attire. That is, you should dress and behave as if you were physically present in the courtroom. Please keep in mind that mediation is for you. You should not bring the children or other family members or your new significant other. Turn off your phone except if needed for the mediation. There is no need to watch videos or answer text or calls except in emergencies. Remember that your mediation will go more smoothly if you are fully engaged in the process and prepared.